Hello, my name is Theodore Gouskos, and I'll be talking about the search and seizure in a digital age, the Fourth Amendment issues, and the legal process it surrounds. So, what is the Fourth Amendment? The Fourth Amendment protects citizens from unreasonable searches and seizures by the government. This does not protect against all search and seizures, but those deemed unlawful. So, what does this mean for digital storage devices and the like? Well, the original Fourth Amendment was made when a physical border like a house was crossed or the seal to a letter was broken. But where's the line drawn on digital devices and the data they create? The case I'm going to talk about is United States v. Jones. In 2012, a trespass test was applied to modern day technology, which involved the attachment of a GPS monitoring device to a vehicle, in which the government pre-obtained a warrant for installing one on the vehicle. What the court has put in place of the common law trespass test was the reasonable expectation of privacy test. This means the GPS data recorded at his private home was suppressed, but the data recorded in public streets stayed admissible since Jones had no reasonable expectation of privacy in the public streets. Although on October 2006, Jones's trial ended in a hung jury on the conspiracy count. But in March 2007, a grand jury returned another indictment charging Jones and others with the same conspiracy. The government introduced at the trial the same GPS-derived locational data admitted in the first trial, which connected Jones to the alleged conspirator's stash house that contained $850,000 in cash, 97 kilograms of cocaine, and 1 kilogram of cocaine base. The jury returned a guilty verdict, and the district court sentenced Jones to life imprisonment. So, why was this case so important? Well, it introduced the application of the trespass test and the reasonable expectation of privacy test to modern-day technology. This allows the court to have a methodology to decide if digital evidence obtained is under the Fourth Amendment. Although both tests should be applied to physical or digital possessions to determine if the search and seizure is constitutional. Next, I'm going to talk about third-party doctrine. This reasonable expectation of privacy extends to third parties where there is no expectation of privacy under the third-party doctrine. Traditionally, this doctrine has been applied in two ways: when people share information or other property with confidential informants or undercover agents, or two, banks or phone companies disclosing records. So, this doctrine was based on two cases: United States v. Miller, where the police issued a subpoena to obtain the defendant's bank records, and Smith v. Maryland, where a pen register by a telephone company was collected. In the case of the bank, there is no legitimate expectation of privacy, and the information was voluntarily conveyed and exposed to employees in ordinary business. In the case of the telephone company, Smith voluntarily punched in the numbers and disclosed this information to a third party, so the evidence was admissible. The reasoning of these two cases can be applied when talking about technologies like the cloud or when websites take in data from users. Although it also has been argued the other way around, in which the data is involuntarily given, i.e., data mining. Lastly, I'm going to talk about warrants a little bit. So, only warrants can compel third parties to share information about clients, and for that data to still be usable in court if it is covered by the expectation of privacy clause. The Fourth Amendment is also implicated in the event the third party chooses to cooperate without a warrant being issued. Warrants have also been deemed required to search mobile phones, specifically as to attest to the case of Riley v. California in 2014. The court decided that the phone itself can be seized if it is believed to be part of a crime or normal inventory process, but the data on it is a separate entity.